So structuring a partnership, and when I say a partnership, I mean generally speaking, joint venture, long-term partnership, whatever. There's a general partnership. A general partnership is two or more parties, could be individuals, corporate entities, and so forth, okay, in business together. In a general partnership, you don't file anything with the state. It's not like a corporation or LLC where you file something. You can have a handshake, you can have a written agreement, you can have something in between, but you can create a partnership without any real formalities. Does that make sense? And a general partnership, as we'll discuss later, has some risks and liabilities that come with it. A joint venture, again, that's another, just a shorter term version of it. But for the most part, the rules of joint ventures and the rules of partnerships for legal purposes and rules are pretty much the same. They're pretty close. So, as I say, in essence, a joint venture is a form of partnership where not all partnerships are joint ventures. A corporation, now that's a formal entity. You can't do that by accident. You can't do that by handshake. You have to form it with a state agency, okay? And then you have shareholders. And you're going to have bylaws and you're going to have agreements between the parties to the entity. A limited partnership. That's different than a general partnership. You have general partners and limited partners. General partners run the show and limited partners put up the dough. So limited partners don't participate. They are limited in liability, they're limited in participation, general partners do it. And for a long time, that's how most syndications were done, limited partnerships, where a general partner would be a developer, limited partners, a bunch of doctors, dentists, and other fools with money. At least that's how the general partner thinks of it. And then that would take on a project as a partnership. Now, in a general partnership, all partners are liable for anything that goes on in the partnership. In a limited partnership, only the general partners are liable, which is why typically the general partner is a corporate entity to avoid that. Okay? Then we have an LLC, which for the most part is going to replace limited partnerships in most cases, not necessarily for asset protection, estate planning, and so forth, but for development projects and partnerships, LLC has become the popular alternative to using a limited partnership or a general partnership. Now, we have other types of entities that you may have heard, like a limited liability partnership, an LLP. What's the difference between an LLP and an LLC? Well, first, they're spelled differently. Some of you got that, some of you will get that later. An LLP is a limited partnership, a general partnership rather, that has limited liability between professionals, usually doctors, dentists, architects, lawyers, okay? So unlike a general partnership where you're liable for what all your partners do, in a limited liability partnership, you're not, okay? You're liable for what you do, but you're not liable for what your partners do, okay? And then we have a triple LP, a limited liability limited partnership, which is one of those entities available in probably about half the states, Colorado being one of them. And that's a limited partnership where the general partner has no liability. Which one? Nobody really uses that anymore, because that's what an LLC does too, because you have managers and members and so forth, which we'll talk about a little bit later. The other way to structure a partnership in terms of entity-wise may not be individual partners at all, or no entity at all. It might be a lender-borrower relationship. And we'll talk about this several times, that there may be a scenario where it makes more sense to be a relationship of lender-borrower than it does to be partner-partner. Does that make sense?